Mr. Wright, is there anything you wish to say or no?
Yes, Your Honor. I'd just like to say that I bought the vehicle to either make a deal with my friend down the road because his truck was the vehicle didn't even have a rear drive shaft on it. I had it ordered for it. I was going to put it on and either sell it or make my friend a deal on it. He only lives like a football field from where I was at. I drove it down, filled my water jugs up for my camper, and I drove it back to the property. And when I pulled in, I noticed in my rear view mirror, there's the county cops behind me. Well, I didn't know it, but my neighbors had called and reported it, which is fine. I was running a generator for my camper, and they didn't like the noise the generator made, but I didn't have any electricity for my camper, so yeah, that's about all I got to say about it. I'm guilty, and yeah.
Okay, thank you, sir.
Yeah, thank you, Your Honor.
Mr. Goodrich, any recommendations for the people?
Buckle up, guys, because today we're watching a courtroom moment where defendant tries to explain the circumstances behind his arrest before accepting responsibility. He tells the judge why he bought the vehicle, explains what happened when police arrived, and even brings up his neighbor's complaints. But despite his attempt to put the situation into context, he ultimately admits he is guilty, setting the stage for a much tougher sentencing discussion.
Yes, Your Honor, thank you. The defendant is 61 years old. He does have a significant criminal history involving 5 prior felonies and 23 prior misdemeanors. The positive is he does accept responsibility as he has today. He did in his interview with the PSI. The negatives is he did admit to drinking since 15 years old. His criminal history all involves alcohol. This is his 6th drunk driving. The current offense involved a .175 blood alcohol level. He's been in jail 11 times prior. He's tried probation 7 times. He's been to prison twice and then failed to appear for sentencing in this case. I think at this point he's top of the guidelines and any time moving forward. Thank you.
Thank you. Mr. Wright, if you please stand for the first time. Good thought, Mr. Wright, as to the contempt of court that you previously admitted for failing to appear for your sentencing and consuming alcohol. I'll order that you serve 30 days in jail and give you credit for 30 days served. That's on the contempt. And then we're here for sentencing on the suspended license and the operating while intoxicated.
All right, guys, this is where the case suddenly becomes much more serious. The prosecutor lays out the defendant's extensive criminal record, revealing 5 prior felonies, 23 misdemeanors, and multiple previous drunk driving convictions. He also points to a .175 blood alcohol level and a history of jail, prison, and failed probation. The judge then begins handing down separate penalties, making it clear that this is far from an ordinary first offense.
For the driving on a suspended license, I'll order that you serve 38 days jail with credit for 38 days served. There are some fines and costs in this case. State costs of $118, crime victims assessment of $130, court costs of $350, and a fine on the drunk driving charge of $500. And as to the incarceration component for that, you've got drunk driving cases. This is your 6th time being sentenced for a drunk driving offense. And you've got criminal history that includes drug crimes, drunk driving crimes, property crimes, and assaulted crimes. From 1979 through 2023, almost without interruption, aside from the times that you were in jail or prison. So, Mr. Wright, it's fair to say that you are both a lifelong criminal and a serial drunk driver. And then, when you were supposed to appear for sentencing on this case, you chose not to come to court. and you absconded from your bond on a drunk driving case and got drunk. Those are really extremely bad decisions.
Now, the judge starts putting the defendant's entire history into perspective. This wasn't simply another traffic violation. It was a 6th drunk driving conviction alongside decades of criminal offenses. What makes things worse is that he failed to appear for sentencing and then chose to drink. The judge openly challenges his attitude, arguing that after so many previous convictions, he should have understood the seriousness of his actions by now.
And then today you come in and want to minimize your behavior. Like you don't think this was a big deal. It's a big deal.
Right.
The first time you were sentenced by a judge for drunk driving, you should have understood that drunk driving is a big deal. You didn't. The second time you didn't get it. The third time you didn't get it. The fourth time you didn't get it. The fifth time you didn't get it. And today, after skipping out on your sentencing and drinking, you're telling me it's not that big of a deal. It is a big deal. People die from drunk driving. They get maimed from drunk driving. I've never had to be at the scene or knocked on a door of a parent, but the officers have. They've had to do those things. And you just are pretty nonchalant about it, even not even showing up for court for your sentencing. Those are all facts, Mr. Wright, that are not taken into account in the advisory guidelines. I believe it does call for an upward departure when somebody with 6 or with 5 prior drunk driving convictions doesn't show up for sentencing and gets drunk. And not just those, as I've outlined, career criminal, lifetime. For that reason, I think that a proportionate sentence is an upward departure, and I'm going to commit you to the Michigan Department of Corrections for not less than 5 years, nor more than 10 years, exercising my discretion under the habitual offender third offense to double the statutory max. Get credit for 38 days, sir.
Comment your opinion, like the video, and subscribe for more real courtroom moments.
And this is where the courtroom reaches its most serious point. The judge rejects any attempt to minimize the offense, stressing that drunk driving can leave families devastated and lives permanently changed. Because of the defendant's repeated convictions and his decision to skip sentencing and drink, the judge determines that the normal guidelines are not enough. The final punishment is an upward departure, 5 to 10 years in the Michigan Department of Corrections. If you enjoyed this courtroom breakdown, like the video, subscribe to the channel, and we'll see you in the next video.